When the Law Society of Upper Canada decided to sponsor a one-day workshop on basic problems in evidence, the response was somewhat larger than was anticipated, and the program was therefore subsequently repeated. The workshops took the form of a lecture followed by a panel discussion in each of the morning and afternoon sessions. The panel discussions were, however, a little out of the ordinary. They consisted of a number of short TV scenarios, each of them followed by a panel discussion examining the various evidentiary problems that arose. In the second workshop, the panels were switched around a little so as to give some variety in opposing views. Both sessions were recorded on videotape, and these programs are an edited version of the discussions of the evidentiary problems arising from the simulated courtroom scenarios. I do not think you will find many clear-cut answers to these fairly common problems. What you will find are discussions of some basic but extremely important principles from which solutions are suggested. This program is designed primarily for the legal profession, though we hope that others will be interested and will perhaps gain some insight into the workings of this aspect of the legal system and the way in which the law tries to reconcile conflicting interests. For the lawyers in particular, citations and references will be given for cases and materials mentioned should they wish to make a note of them. There were in total 4 panels, of which 2 each discussed separately half of the fact situations. On the first day, chairing panel number 1 was the Honourable Mr. Justice Edson Haines of the Supreme Court of Ontario. With him appeared Mr. William Poole, QC, practicing in London, Ontario, and a member of the Ontario Law Reform Commission, and Professor Hugh Silverman, QC, a practitioner of many years' standing, and now Professor of Law at the University of Windsor. Chairing panel number 2 was the Honourable Mr. Justice Thomas Zuber of the Supreme Court of Ontario, and with him were Mr. Clay Powell, QC, Counsel in the Ministry of the Attorney General of Ontario, and Professor Desmond Morton, QC, who is both a practitioner and a law professor at the University of Toronto. Mr. Justice Zuber also chaired the first panel on the second day's program, and appearing with him on that occasion were Mr. Justice Frank Weatherston of the Supreme Court of Ontario, and again Professor Hugh Silverman. Mr. Justice Haines chaired the last panel, again with Mr. Clay Powell and Professor Morton as the panelists. As a result of the editing, panel discussions do not always appear in the order in which they were presented. In this 12th fact situation, the panel turns its attention to whether there is a rule that you must cross-examine an opposing witness if you intend by subsequent evidence to attack that witness. Cases frequently arise when a witness for the prosecution, for example, presents his side of the story and defense counsel does not cross-examine, but later on he asks questions of his own witnesses that attack either the character or the credibility of the first prosecution witness. Should that witness first be allowed to explain or contradict that evidence on cross-examination by defense counsel? If defense counsel fails to cross-examine on that point, is he later barred from raising it at a later stage?
In a rape case, the defense's consent.
David, while you and Kathy were sitting in the car, did any conversation take place between the two of you?
Yes, well, before we, well, you know what we did. We sat in the car for over an hour, and she told me about her other affairs, and that she was on the pill, and that sometimes she took drugs.
Surely, my lord, this whole line of questioning is improper. None of this was put to the complainant when she was testifying, and my friend had plenty of opportunity at that time to confront her.
Let's get back to Clay Powell for a second. Although we're hopping from criminal to civil, I don't think that there's necessarily any difference in principle. Both evidence acts, Section 9 of the, I'm sorry, I perhaps got the wrong sections, but 10 and 11 in the Canada, 21, 22 Ontario, don't bother looking at them. They both say that where a witness is cross-examined, you can use a prior inconsistent statement and so on. And it goes on to talk about this. And then about mid-paragraph, it said, if, however, it is intended to contradict the witness, attention must be first drawn to the circumstances of the making and so on and so forth. Now, my question is, do those sections have anything to do with this problem? Is that mandatory requirement to draw the attention of the witness to the statement hinged to its use in cross-examination, or is it of general application? And must you draw the attention of the witness to the statement and so on before you're going to use it at all in your own case? Mr. Powell, the Canada Evidence Act would be your cup of tea, but how would you...
I just don't see it arising in this one. I know in the next segment we do, it sort of comes up in relation to the Canada Evidence Act, we deal with it. I don't know that it's a problem here or has any application at all. I'm sorry, I don't see that the situation. I might say, just by way of comment, of course, that I think that kind of a tactic, if somebody follows it, is playing right into a Crown's hand, because you know, if they don't cross-examine the girl and then to go up and let the fellow bring out the story, it puts the Crown in a very nice position to go to the jury on the fact that, of course, they'd never ask the girl these questions, but wait till it comes up. I mean, I think tactically it's a very foolish move to do, but it's sometimes done.
Well, no doubt I didn't make myself clear. I'm thinking here...
I was trying to get you away from that.
All right.
This question was drafted to illustrate just one point. In a rape case where the defense intends to give evidence of a dialogue that passed between the complainant and the accused, can the accused, through his counsel, neglect to put the very dialogue to the complainant and throw it in at the end of the case? Now, I throw this out for your discussions, if you will. It seems to me that whether we call her a complainant, she's just a witness. And if you're going to contradict a witness, you must come within the provisions of Section 10 of the Criminal Code. And it requires you, does it not, to put to the witness as a condition to contradiction the essence and substance of that dialogue. And with that in mind, how can this question be allowed? Now, what's your view, Clay?
I agree. I don't think it can be or ought to be allowed. There's authority for the proposition, a case by the name of Dick in the British Columbia Court of Appeals, DYCK, in 1970, and where in that judgment is also quoted a judgment of Lord Herschel in the case of Brown and Dunn in 1893. I thought it was a House of Lords case. My friend Mewett advises me it's a Scottish case.
Well, we still think it's a House of Lords.
I still think it's a House of Lords case, but I couldn't check it. But in any event, in that case, Lord Herschel says, "My lords, I have always understood that if you intend to impeach a witness, you are bound, whilst he is in the box, to give him an opportunity of making any explanation which is open to him. And as it seems to me, that is not only a rule of professional practice in the conduct of a case, but is essential to fair play and fair dealing with witnesses." I think that properly states it better than I can. So.
Right.
I'd adopt that too, except that the Brown and Dunn case does say, and I believe Clay mentioned this before our panel, that there may be exceptional situations
where it's obvious.
Where it's so obvious
Yes.
that you don't have to cross-examine.
But this question of confrontation, as a matter of fairness, requires you to put it to the witness while he or she is in the box, so as to afford them the opportunity of giving such explanations as they may see fit.
To refute that, too.
All right.